we'd like to pay our respects collectively to elders past, present, and emerging, and acknowledge the ongoing struggle for justice and reparations by our First Nations communities in this country. Um, so it's been a while since we saw some of you, at least I hope, at Queer Love-In, just as COVID was kicking off. And also a while since we spoke to you about the Religious Discrimination Bill. Sadly, there's been a negative development, which means we felt the need to come together today to talk about this new bill that's on the horizon in New South Wales. We'd like to say, first of all, that if anyone has any questions throughout this briefing, we are going to keep it under an hour, even shorter, depends on you, how many questions you have, but do feel free to flick them through on the chat function, and we'll be moderating and asking questions of each other as we progress. So you'll be hearing from me, just a short intro, and then our legal director, Ghassan, will be taking you all through the details of the bill. We think it's of enough concern that it's really important that our supporters in our community are aware of just how dangerous it is. And then Paige Burton, our engagement advisor, will be having a chat to you about what we're doing to combat this piece of legislation, but also how you can get involved in the campaign. So there'll be plenty of time for questions as well at the end. But if, like I said, if you've got anything burning or pressing, please do shoot it through on the chat function. We are recording the event, but we're going to edit it at the end in a way that protects people's privacy and look at how we do that. If you do have concerns about being recorded, for instance, your image or your name, please do. I'd suggest that you turn your video off. And if you just have any concerns generally about the recording, just drop us a line about that as well. But the reason is because we know there's some people that couldn't make it today that are keen to get this information in some form. So it may be that we send the slides and the audio or something like that if people are concerned about privacy. So without further ado, let me move on to the presentation. Ghassan. Okay, well, here we are. Obviously, it's hard to believe that it's nearly 3 years since we all worked together to achieve marriage equality. Sadly, since then, we have seen many threats arise to our communities, and I guess a new force in the religious right to an attempt to reclaim their price for our equality that was won so hard by many of us back then. As well as the Religious Discrimination Bill. Federally, we've seen this new development in New South Wales. But I just want to give everyone a bit of an update on the federal bill, since I know so many of you have been following that closely. You've taken action, you've written to your MP, and we wanted to let you know where that's up to right now. As you may recall, we were due to have a third version of that bill, or indeed a bill introduced to Parliament sort of late in March, but then COVID-19 hit us all, and we've been reeling for the impacts of that pandemic since then and grappling with that. And on that note, I hope everyone is keeping well and safe, particularly our friends in Melbourne. But the bill effectively at that point was put on the back burner. Now, the government hasn't stepped away from that legislation, but Scott Morrison said in a press conference a couple of months ago that effectively it is in abeyance until the government can return to normal and continue its consultation, particularly with the health sector. So we're, just so you know, we are staying in touch, in close contact with the Attorney General's office and many parliamentarians from all sides of politics in Canberra, just so that we can make sure that we are well aware of whether this federal bill is going to come back on for debate, because we were all working very hard to make sure that the more dangerous aspects of that bill, that everyone knew they should be concerned about it, and we're trying to get that bill opposed by as many people as possible. I felt like we were just reaching some really fantastic momentum with that campaign, just as COVID hit. It was very strange timing. Anyway, here we are now in New South Wales with a development whereby Mark Latham has initiated a private members bill on the same topic, religious freedom. And usually private members bills wouldn't worry us so much, but in this case, what has us quite concerned is the fact that the New South Wales government, in fact, the Attorney General has moved a motion to initiate an inquiry into this bill. So effectively asked the Parliament, should this bill become law in New South Wales? So we need to take this seriously, and we need to make sure that the New South Wales government in particular hears a clear message from us, from the community and from civil society more broadly, that we need our laws to protect us all equally. And we need to make sure that any anti-discrimination law protects not just people of faith, but those protections don't come at the expense of others. And certainly this bill is as absurd and extreme as you would expect a One Nation religious discrimination bill to be. And I think that's where Ghassan's going to take over and have a look at some of the more disturbing aspects. Just to give you some context before we do that, I thought you'd all, for those that don't know Mark Latham, I'm sure you all do, this little quote here gives you a good sense of his views on LGBTIQ people and some of the motivations behind this legislation. So I'll just read it out. He said in his second reading speech, every letter of the alphabet seemingly has a flag, a network, a special ceremony to affirm and celebrate its identity, except the letters C and H, Christians and heterosexuals. So he's clearly positioning this bill as against LGBTIQ plus people. There's no ifs and buts about it. So that certainly gives you some context. I know many of you will be familiar with the sorts of comments that Mark Latham has made in the media. He's very anti-trans rhetoric. He's really distasteful and offensive comments about our communities more broadly. So we have every reason to be concerned that this bill will impact on us, but indeed impact on women, people with disability, and indeed, ironically, people of faith as well. So Ghassan's going to take you through some of the detail. And
thanks very much, Anna. Hi, everyone. Thank you for joining us. I will try and unpack the legislation that we're seeing in New South Wales. And I'm really happy to answer any questions that come up. If you want to send any questions to through the chat function to the account that's described as send questions, if I can't get to it as I'm speaking, we will get to it later on in the presentation, and we can also provide you information after this presentation. So let's start really at the beginning. What is this piece of legislation trying to do, and what are our concerns about it? This is, first of all, legislation that's supposed to try and provide protection to people against discrimination on the basis of having a religious belief or engaging in religious activity in certain areas of public life, like employment, in the provision of goods and services. And it's supposed to also protect those who have no belief, i.e. atheists. In New South Wales, we already have some protections for people that are described as ethno-religious origin protections. What that means is that some groups can find protection today in New South Wales. For example, Jewish people and Sikhs have been found to already have discrimination protections on the basis of their ethno-religious origin. So this is adding another attribute to the existing legislation to ensure that it covers broadly all religions. But the way it's doing it is really where the concerns arise. So if I could give you an example, and I'm going to take you through different scenarios today so that it really illustrates for you where the concerns are. So I want you to imagine these scenarios. You have an off-duty police officer or a teacher outside the classroom who makes anti-LGBT or anti-Muslim statements on their LinkedIn profile or a Facebook account, which is motivated by their own religious beliefs. And these are seen by members of the community, including, say, a woman who knows that the police officer works at her local station, or parents who see the statements made by the teacher, and they go to complain to the school. Now, I'll come back to what this bill says about what the school can do in respect of that teacher. But also, another example is a doctor. And this is a doctor with Christian beliefs that homosexuality is sinful. And they are asked by a family friend who goes to the same church to see a young man that is part of their congregation who's struggling with his sexuality. This young man comes to visit the doctor at his home, so outside of the workplace. And the doctor suggests to the young man that he seeks the assistance of a Christian counsellor about curing or suppressing his homosexuality. So those two examples are aspects that would be concerns for us under these clauses, which we've called the no consequences for conduct clauses. And what these clauses do is they say that an employer, an educational institution, and qualifying bodies, so that is an organisation that licenses or provides qualifications for particular professions like doctors, those organisations cannot restrict their employees, students, or their members from engaging in activities that are motivated by their religious beliefs that occur either off-site or outside of work hours. Now, there's some exceptions, and I'll come back to them, but let's look at the examples that I mentioned. So the off-duty police officer could not be responded to by the New South Wales Police Force. The school couldn't respond to the comments made by the teacher by, for example, asking the teacher to remove their comments or refrain from making comments, even if they are influenced by religious beliefs, because of the harm that those comments might make to others, or the breakdown in community trust that comes from having, members of the public or public servants that have the requirement to maintain trust with the communities that they serve, make sure that they remain impartial. So what these provisions do is limit the ability of an employer, an educational institution, or qualifying body to respond where someone outside the workplace engages in activities that are motivated by their religious beliefs, which nonetheless cause issues for others, like co-workers, for students, for clients or customers, or for members of the public. So these are very closely modelled on the Israel Folau style scenarios, but the concern here is they don't just apply to private organisations, they apply across the board. So they also apply to public servants like teachers and people like nurses or others that might be employed in public roles. And they apply to bodies that regulate those professions. So bodies that regulate doctors, nurses, psychologists, pharmacists, all of those disciplinary style bodies are also restricted from placing restrictions or responding to activities that are engaged in by their members outside work hours or outside the work site. So, outside of their clinic. But the real concern here is around how these provisions allow things to happen in those spaces which prevent employers and educators and qualifying bodies from being able to respond when those activities are inappropriate for that particular, where they harm others for that particular profession or employee. So there's some exceptions. They don't apply to activities that themselves amount to imprisonable crimes. That is, not all crimes, but some crimes that you can be sent to jail for. They won't cover, breaches of those kinds of criminal offences. They don't apply to any activities engaged in by someone which involves directly criticising the organisation that employs them or the member. But as we saw with the Israel Folau case, Israel Folau, for example, wasn't criticising Rugby Australia, what he was doing was spreading views criticizing everyone else. And this law says that harm that you cause to others doesn't matter. It doesn't allow you to respond when that harm is created to everyone other than the organisation. And there's also limitations on activities that cause harm financially to the organisation that employs them. But again, the problem is the way that that's been defined. First of all, it really allows people to harm others in ways that are motivated by their religious beliefs, and then prevents an employer or an educational institution or a regulating body from being able to respond. Anna, did you have a question there come through? So, oh, right. Sorry, I've just got to unmute Anna to allow her to ask the
Thanks,
question.
Hassan.
There we go.
What a way to interrupt your presentation. We just did have a question from someone. Could you possibly elaborate about the differences between the federal bill and this bill?
Yeah, so this bill, well, first of all, the federal bill obviously applies across Australia, and this applies to businesses or services that have a connection with New South Wales. So this bill is really, they both could apply at the same time, but this bill is dealing with basically people who are employed in New South Wales or who provide services to people in New South Wales. So doctors and teachers and police officers, etc., that might be in New South Wales. The federal bill dealt with what they called statements of belief, which was really about people saying things or people writing things. And it also limited what could be said to make sure that they weren't things that harassed others or that threatened others or that humiliated others. Sorry, not humiliated, but seriously intimidated others. So it was very much defined that employers couldn't respond to people who said things that didn't harass others, so express their religious beliefs in this way. The New South Wales bill doesn't have all of that language. It deals with activities, not just what people say, but things that people might do or refuse to do, provided that they don't amount to crimes that people could be sent to prison for. And it doesn't have all of those caveats about, that the conduct can't harass others or it can't seriously intimidate them. So provided it isn't a crime, and it doesn't criticize... An imprisonable crime. An imprisonable crime, and it doesn't criticize the institution that employs you or that you're a member of, and it doesn't cause that institution certain types of financial harm. And that harm can't include loss of sponsorship or loss of customers or anything like that. Provided it doesn't include those, then basically there can be no response. And so the issue is not about restricting people from being able to express their religious beliefs in private as they wish, which is absolutely something that people should be able to do. It's about people who use their religious beliefs and are motivated by those beliefs to actually harm others, engage in conduct that harms others, and it prevents employers and educational institutions and qualifying bodies from being able to respond to those instances.
Ghassan, we've got another question.
Mm-hmm.
Does the bill only apply outside the workplace?
So this is another tricky thing about the legislation. Yes, but the way it defines the workplace is really interesting. So it says that it has to happen outside the hours of the person performing work and off-site. The problem is, let's take a Christmas party as an example. You've got a bunch of colleagues at a Christmas party and one colleague says something to another colleague which is offensive or that discriminates against them on the basis of their disability or their gender or their sexuality. And that person engages in that activity or that conduct informed by a religious view. So a really good example is someone says, a comment to a trans co-worker that basically that they believe that that men and women are created, and biological sex must define the way that that their gender identity, and that they will not use the person's name or pronoun to refer it. So they will constantly misgender that person in the way that they refer to them at, say, a Christmas party or outside the workplace or on Twitter or on Facebook. This provision suggests that if it happens offsite or outside of those work hours, that person can completely go ahead and mistreat that person, their co-worker or a customer in that way, without the employer being able to say, well, actually, that breaches our codes of conduct, the importance of maintaining an inclusive environment where everyone who comes to an event that's associated with their work, or whether it's a Christmas party or during a break, can feel free and safe at work to be part of this workplace. And so where the line is drawn between what's inside of work and what's outside of work is very, very tricky. And this bill in particular has some really problematic lines around what is considered in and outside of work. And of course, if you're talking about a teacher or a police officer or a psychologist or a pharmacist who expresses views outside of work that are really contrary to the kinds of values that you expect people in those positions of trust to hold, it can break down community confidence in their ability to do the job during work. But because they've expressed those views outside of work, an employer can't respond.
And I think you've almost answered this question, Ghassan, but someone's asked, could a doctor publicly share transphobic views on the weekend but continue working as a doctor without sanction?
Yes. That's that's what the special read, the second reading speech uses as an example. A doctor who has a question around their accreditation because, and this is the words of the second reading speech, they don't accept gender fluid ideology. So that's the language. These are the precise examples.
And I'll let you move on. Yeah. I'll let you move on soon, Ghassan, but just one more question. Does it apply to NGOs and charities?
It can, and I will come to some specific clauses that apply to NGOs and charities, but it's really talking about things like people who provide services and people who employ others or provide education to others. So it doesn't really matter whether you're doing that commercially or in a non-profit capacity in some cases. It depends on the thing that you're doing or the conduct.
And they're coming thick and fast now. Someone's asked, does it not interact with social media policies?
So it overrides any social media policies because this is a discrimination law. It sets the kind of the parameters in which you can frame a policy or make a contract. So if you've got a contract with someone or you've got a policy with someone saying this is what is appropriate conduct at the workplace, but that contradicts what's in this law, and this law is passed by Parliament in the way that it's drafted, it would say you can't have that policy, or enforcing that policy is a breach of the law. Anything else, or should I move on to the...
Move on while you can.
Okay, cool. All right, so this is now moving on to the second area where we have concerns. And if I could give you these scenarios. So imagine a faith-based homelessness service that receives public funding to provide services to people who are homeless, or strongly encourages those people to attend a prayer group as a condition for accessing meals. So think of that scenario. And in another scenario, for example, you've got a faith-based hospital that receives public funding. It wants to employ a manager, but it advertises a manager that only believes in the same faith as that hospital has. or you have a non-denominational Christian school and it refuses to allow a Muslim girl to wear the hijab as part of the veil, as part of her school uniform. So what does the law say, or what the proposed law say about these sorts of institutions? So one of the big concerns about these provisions is that it adds and expands the exemptions that are already available for faith-based schools, charities and bodies to discriminate against others, in this case with different or no beliefs to the religion of the body itself. These exceptions are in addition to those that are already under the law. So New South Wales has protections for grounds like sex, homosexuality, transgender status, etc. And religious bodies already have very broad exemptions for those grounds. So this would be adding to the exemptions that exist, effectively allowing faith-based organisations to, in addition, also discriminate against others who have different beliefs in the way that they employ or provide services or educate. Any questions now, Anna, or should I move on to?
There are actually a couple, and we might deal with them because they deal with what you were talking about previously. Firstly, is hate speech or vilification included in the definition of imprisonable offences excluded?
So very serious hate speech can be a crime under New South Wales law. And so very serious vilification might not be protected. So if the religious activity involves very serious vilification. However, there is also vilification protections in New South Wales on the grounds of homosexuality, HIV/AIDS status, race, and transgender status that are not defined in the same way as a crime. They're defined slightly less severely, so it captures a broader range of conduct. And those provisions are civil, they're not criminal. That means that if you breach them, you don't get arrested or charged, but what can happen is someone else can bring a claim against you for the harm that you've caused them and others. Those vilification protections don't amount to a crime, and therefore that kind of vilification could be protected if it's done in the name of a religious belief. And of course, a lot of obligations that people have to each other don't rise to that level of a crime that is imprisonable. Driving offences are a really good example. Most of the time, all you get is a fine. You don't, offend a criminal provision that someone can send you to jail for. Another example, a lot of professional obligations. So lawyers and doctors and pharmacists, they all have to engage in their practice in a professional way and not engage in misconduct. All of that is basically civil obligations. They're not criminal obligations. So, or breaches of confidence, people who commit acts of negligence that cause harm to others, all of that don't rise to the level of serious criminal conduct that would be excluded by the protections offered in this bill.
It's a scarily broad range of conduct.
Yeah.
And just one more question on the social media policy.
Yeah.
We might have to take this one on notice, but wasn't there legislation, or I think it was in fact a case that made the page owners legally responsible for discrimination and abuse on their page? How would this legislation change that dynamic?
Can I come back to that at the end?
Yeah, I thought that might be one of those.
I think the answer really is it really depends on a lot of things. And one of the things is if you are providing a service of a platform to others, the question is, are you potentially discriminating against others by refusing them the ability to engage in your platform because they're making hateful speeches? And so the question is, if their hate speech is informed by their religious belief, could they then sue you for religious discrimination? Possible, but I think it really would depend on the circumstances about whether or not the way you treat others who engage in hate speech, whether informed by religious belief or not, and it would also be determined by whether or not it's reasonable for you to engage in that kind of policing of, or that enforcement of standards on your platform. So complicated, and it would really depend on the facts.
Yeah, absolutely.
Okay, let's move to then our third big area of concern. We've described this as the clauses that deal with what we say is establishing effectively a religious Bill of Rights. So here are three more scenarios for you to consider. Say the New South Wales government puts out a public tender for organisations who are willing to provide foster care services. So what that organisation is supposed to do is look at applicants who want to become foster carers, assess their eligibility, their suitability to provide those foster care services, and match them with children who are in need of care. But the New South Wales government says that to be awarded this funding, you must provide your services to anybody. That is, you have to accept applications for foster carers from everyone. And a faith-based organisation wants to apply, but doesn't agree with accepting same-sex couples as foster carers, and will not accept a condition in its funding contract from the New South Wales government that it does. So that's one scenario, and we'll come back to how this interacts with the provisions. Let's say there's a religious institution that wants to hold a public worship service for 500 people at Christmas, and COVID restrictions, which are made under a New South Wales law, limit gatherings to 100 people. And in another example, let's say there's a Muslim taxi driver who objects to accepting a passenger with a guide dog because of religious beliefs regarding dogs as unclean. So those three scenarios, how would the One Nation Bill respond? So the first thing the bill does is it establishes a right for religious organisations. So this is significant, first of all, in that it's giving human rights to a legal entity, not just an individual, but to religious organisations and individuals to be able to challenge a New South Wales government program, policy, contract or decision that discriminates against their religion. Discriminates in the sense that it doesn't allow them to act in a way or to omit, or that is not act in a way which contradicts a religious belief. So going back to that foster care scenario, this is a faith-based organisation saying to the New South Wales government, you requiring us to provide our foster care services to everyone, including same-sex couples, is a condition that is unreasonable because it discriminates against our beliefs that same-sex couples shouldn't be accepted as parents of children. That would be an example of a case. The other is the COVID example. So the COVID restrictions are made under public health laws by the minister. It would be saying to the minister who made that decision to restrict public gatherings to 100 people, that discriminates against that religious institution's ability to worship in congregation with others, and that the minister's decision's unreasonable for whatever reason, including, the risk of COVID versus the harm that's created for people of faith not being able to congregate and worship together. That would be an example. In the case that we talked about with the guide dog, the second issue that this bill creates is it puts religion, the manifestation of a religion, with a special status. So in any discrimination complaint that's brought under New South Wales law, you have to engage in this balancing approach where religion is given a special consideration. So in working out whether or not the Muslim taxi driver refusing the blind passenger with the guide dog a service, that would be pretty clearly disability discrimination. But you'd have to factor in whether that discrimination should be permitted because you needed to accommodate the religious beliefs of the taxi driver as well. So when you do that balancing as between different complaints, what this bill does is it puts religion up the top in the what they call the objects of the Act. So when you're considering complaints or making decisions under the Act, you must consider religion in a special way.
And
as we,
it won't include any other attribute for special consideration, only religion.
It says that you must consider human rights generally, but then it goes into saying, and when we're talking about limitations on the manifestation of religion, you have to consider that those limitations are no more than necessary to limit the manifestation of religion, etc. So notwithstanding at its beginning point, it starts that we look at human rights as a whole. The way it's drafted is really to tip the balance much further in favour of the expression of religious belief over other interests like public health, public order, discrimination against other people, and a range of other criteria. And yes, no other ground looks at the impact on other people in that same unbalanced way.
Thanks. I've got another question about exemptions, but do you want to move on? I can't remember if you're dealing with that next.
Yeah, I'm coming to people of faith, but I'm happy to.
Yeah, so the question is, as you've mentioned anyway, schools and other organisations already have really broad exemptions, including exemptions to discriminate against LGBTI people. How does this bill expand them?
Yeah, so let me actually come to it now, because there's one of the things about this piece of legislation is it dresses it up as a religious discrimination bill. But then when you look at it, it doesn't really provide people of faith with equal protection. In particular, it doesn't provide all types of faiths with the same protection. And this is why. The first thing is, there's already, as I mentioned, the ethno-religious ground for protection. So Jews and Sikhs are people that are protected already under the New South Wales law. They're also protected not just in discrimination, but in vilification. So if someone severely ridicules people of Jewish faith, for example, that is in and of itself a protection. This bill does not expand those protections to other faiths that are not currently covered by the ethno-religious ground. And the most obvious example of that is it doesn't protect Muslim people when people say things that are Islamophobic in a way that incites others to be violent or to have so the hate speech examples. The other thing is with the faith-based exemptions, because numerically you have a very large sector of Christian organisations, all those organisations will be able to prefer or refuse service or prefer employment of people who share their own faith. So discrimination by schools, charities that are of particular faiths will be able to exclude people who have different beliefs. And the way that these exemptions have been adding to the existing religious bodies exemption. And not only does it add the exemption, but it adds it in a way that's very broad. It talks about religious ethos organisations being able to engage in activities that further their religious ethos. And what is the religious ethos? It's basically defined by the religion of the organisation itself. So it's very circular. It gets to define for itself what its religion is, what its beliefs are, and then provided it just engages in activities that generally conform with those self-defined beliefs, then it doesn't have to provide other people of faith or people within its own faith within that have different views on questions of like doctrine with the same protection.
Someone's actually asked, this is a bit of a segue, is there a definition of religion in the bill?
No, there isn't a definition of religion, provided that there's provided that the activity isn't an imprisonable crime, then it leaves open to religious belief, that we would broadly understand includes all of the traditional faiths. So what happens is basically, I think a court would look at that absence of a definition and just ask itself, where else have we looked at what religion means? So there's a Scientology case, for example, that tells us that Scientologists can be a religion. What we know is it will cover really just the traditional religions at the very least. So Christians, Muslims, Jews, Hindus, Buddhists. It will probably also cover denominations or sects or particular streams within those major denominations. And all of that will just be tested as claims are brought forward to whether or not a particular religion is a religion. The other thing it covers is people who don't have a belief, so atheists.
Yeah. And someone has asked about the infamous baker who doesn't want to bake a cake for a same-sex wedding. Where does that scenario fit in this?
Yeah, I'm actually really worried about this because of the way that a religious ethos organization is defined. It talks not just about schools and charities. It talks about any body meaning a legal entity, any entity that has been defined by some religious view. And it doesn't have any limitations to say it has to be a not-for-profit entity or an entity that provides particular services. So my concern is that the baker that is, a Christian baker or a Muslim butcher or whatever could start saying, well, you have to consider us as a religious organization, which means that they get certain exemptions, and also you have to consider discrimination protections by balancing the rights of a commercial body to discriminate in accordance with the operators of that body's religious views, as against any LGBT person that wants to walk into that shop or access the service or even seek employment. But it's not a broad, like, absolute exemption, but there is a concern that it opens the gates for those kinds of bodies to also seek recognition of their commercial activities as being religious activities effectively.
I've got two more that I'll just rattle off quickly and then you can respond. One is, does this limit the ability of services and organisations to require staff to do inclusion training? Good question. And this one's a funny one. How could this law be used to constrain one nation's ability to operate?
Well, can I do with the second one first? Because I think if anyone has followed what One Nation has been about for the last 10, 20 years, and all their rhetoric on things like banning the burqa and the Muslim Sharia law or halal or any of that sort of stuff, it's really interesting what's in the law as well. So there's a provision that deals specifically with religious dress in the workplace, and it says it will be reasonable to prohibit someone from wearing a religious, it will be reasonable, but when considering when it is reasonable to prohibit someone from wearing religious clothing as part of a work uniform or in the workplace, you have to look at a number of things. And one of the things you have to look at is the ability to communicate and industry standards, which are super, broad and very not subtle, I would say, but very kind of implicit nods to the French ban on burqas, where the courts, the European Courts of Human Rights looked at those issues. And then in the second reading speech, they refer to further notes that explain examples of the legislation. And one of the examples that's used by Mark Latham is a woman in a full face covering applying to be a bank teller. And it would be reasonable for, and not discrimination, for that employer to turn around and say, we can't employ you because we require bank tellers to show their faces. So, you know, so it's been drafted in a way so it doesn't put One Nation's policies on things like ban the burqa and other things under the microscope.
He clearly prefers some religions over others.
Absolutely. And if you read the second reading speech, almost every single example that's used is about the Christian photographer who doesn't want to provide same-sex couples with wedding photos. It's about the Christian doctor who doesn't ascribe to what they call gender fluid ideology. It's those examples. It's the people that oppose same-sex marriage because of a biblical view of marriage. That's
very Christian examples.
Absolutely.
Now, I'm conscious of time. We've got 11 minutes left. I've got a couple more questions, but I also want you to be able to finish your presentation. I'll just rattle them off again. How does this, and you've actually just answered this, how does this bill deal with the religious discrimination paradox where someone is being discriminated against for their religion when applying for a job, in that instance, from a religious organisation?
So the organisation trumps, effectively. Whatever the religion of the organisation is can define how the organisation operates.
And could this affect women, trans people in obtaining hormones and birth control, etc., from religious chemists?
Yeah, so this is really difficult because it gives so putting aside abortion, for example, and areas where the law has very clear rules around the refusal of treatment based on religious beliefs, it does leave open the ability for a pharmacist or another health professional to question professional standards that require continuity of care for a patient where their religious beliefs conflict. So it's not clear how it would resolve, like whether or not the chemist would have to provide that treatment to the person seeking it, but it would put the religious belief up against the other person's rights in a sort of a balancing test, and it's not clear where that would be resolved, although you would hope it would resolve in favour of the continuity of care of a patient rather than so we're talking here about rights of referral, providing information or referrals where you're not willing to provide the service yourself, and those sorts of rules. It's very uncertain how it will resolve in those cases.
Okay, I'll let you keep going and power on through.
So I just wanted to quickly touch base on where it's at. So the bill was sent to a joint select committee of New South Wales MPs. And you might not be familiar with all these people, but these are all members of upper and lower house of New South Wales Parliament. You can see some names that may be familiar who, we would consider as quite friends of our community, people like Alex Greenwich, who you'd expect would not have a desire to see laws that reintroduce discrimination or allow discrimination against others. But we also know from the track records of some people like Greg Donnelly, who, their voting records have been very anti-LGBT in the past, and you can see, Mark Latham there, Joe McGurr, who voted against the abortion reforms. So, to put it in a nutshell, I think the problem is this committee is very much stacked against us in terms of people who may take the view that people should be allowed to use their religious beliefs to discriminate against others, particularly LGBTI people. And in terms of where things are at in the process, so the bill was referred to that committee on the 18th of June. We're currently in this consultation phase. So there's a survey, which I'll hand over to Paige shortly to speak about, and submissions are being called for, and all of that is due by the 21st of August. and the committees then will consult and finalise its report by the 31st of March next year.
Yeah, and those reports, for those that don't know, will contain a number of recommendations that the government would generally respond to. Over to you, Paige. Otherwise
Hello.
known as today as send questions.
Yes. Sorry. So if people do have questions, keep sending them to me, but I probably won't read them until I stop talking, but that's okay. We'll be okay. So just quickly, and we've had a few questions about this. There are a few things that you can do at the moment. Ghassan sort of outlined the fact that at the moment we're in a consultation phase. This consultation is a little bit weird and a little bit different to how things usually happen. And one of the things that is quite different is the committee actually have a SurveyMonkey survey open at the moment for members of the public to do. And so we really encourage you to go and do that survey. So we've made a little bit.ly link to it. It's not our survey, it's the government's. And that's the most important thing you can do right now for us. So that's there, but before you go and write your answers to the survey, really encourage you to go have a look on our website. Ghassan's done a heap of work explaining the bill, bits and pieces. And really encourage people not to use sort of our language or our analysis, but to like be informed by that and share your own stories, your own narratives, why this is important to you and your community, so we can sort of show the diversity of people who are responding to this. We anticipate, you know, some other organisations will be sending this out and they will not be so friendly to us. So we really encourage you to go and do that. The next thing is to go and write to your local member in New South Wales or the Attorney General or both of them. Again, we don't have a template for this at the moment because we really want people to focus on doing that survey because that's a direct ask of the public and that will go straight to the committee. So that's the first step. If you want to write to your MP, we haven't got a template letter up at the moment because of that priority, but we do have a lot of analysis and we really encourage you to check that out. Pick a few things that you think are pretty egregious and explain why with relation to who you are and you living in your community and your electorate, why that matters. A few people have asked, should we be doing submissions? Our personal thing is we're not telling individuals to do submissions. We obviously encourage you to do whatever you think is appropriate, but we really first encourage you to go and do the survey. If you want to do a submission, that's fine, obviously, but if you are part of an organization, that's better. So if you're part of an organization, there are lots of other things you can do as well. If you think back to the federal campaign, we've built this really broad coalition and we'll be doing that again. So last year we had unions, business associations, corporations, women's organizations, disability organizations, LGBT organizations, individuals, sports people, local councils, health organizations, professionals coming together and standing together against this bill. I want to do the same thing in New South Wales because it really does affect everyone. This is not just about our community, it's about all of the different pieces of people who live in New South Wales and making sure that our laws protect everyone equally. So if you're part of an organisation that wants to get involved, there are lots of different things you can do. We'll probably be doing some joint statements from different sectors and there's heaps you can do there and we'll help you with the submission writing process if you are keen to do that too. So they're the main things at the moment. Obviously you can donate and support our work. Ghassan spends loads and loads of time on legal analysis and briefings. We've got a bunch coming up with different specific community groups, which takes up a lot of our time, but we're obviously very happy to do that. So if you have the ability to contribute, that's great too. But we'll definitely have a lot more to do over the coming months and we'll have more and more actions for people to take. If you want to get involved in the campaign, you can email me at info@equalityaustralia.org.au. But for now, we really encourage you to do the survey. It's at bit.ly/One Nation Bill survey. A few people have asked as well, will we be getting these slides? Yes, we will send them to you, so don't worry about frantically writing everything down. I'll send them this afternoon, send these details to you so you can go and do that as soon as possible. That's a lot of things, but we will continue to update you about the different actions, about the different developments and any more analysis that we do. But I'm going to throw it back to Ghassan to kind of wrap this up, and there are a few more questions, so I'm going to go and do that and read your questions. But if you have any for me as well, stick them in the chat and I will get to them.
Thanks, Paige. I had one question that came through is what happens when two people or organisations of different religions are discriminating against each other? Who has protection under the bill? The simple answer is they both have protection, and how it's resolved will depend on the context, the circumstances, if it's an organization versus an individual. But if we're talking about individuals, they both have protections, and you'd expect there'd be some balancing to occur. But the bill doesn't really answer how you would balance those sorts of conflicts.
Okay, well, thanks, Ghassan. Just waiting to hear from Paige. It's 1:29. I think we're going to deliver on our commitment to finish within the hour, which is amazing. Also, I'd like to thank, we're already working closely with groups like ACON, the New South Wales Gay and Lesbian Rights Lobby, PIAC, and others. We're really looking forward to working with all of you and across our community to make sure this bill goes absolutely nowhere. Thanks for your time. And please do, if you've got any questions, shout out like Paige said. And we've got some questions coming through. If you do need to leave at 1:30, that's okay, but we're going to keep answering questions for those that are interested. We've got a question: will the committee care about views outside New South Wales? I think it's fair to say that they'll care less, but they have, specifically in their terms of reference, they're looking at submissions made to the federal process recently. So they'll be looking at submissions made to that, and also considering the views of the Ruddock Review Panel. So it's fair to say that if you're a national group or a group in another state or territory that has some expertise, has a view that on these issues, I think that does carry some weight. If you're interested in whether it's worth the effort and just want to chat to us quickly about it, we're more than happy to have those discussions. Ghassan, is there anything else you'd like to add?
Got a couple of questions here as well. So just quickly, first, in response to the people who are saying the survey is only 3 questions, which is, do you support this? Do you oppose it? And why? That is true. So we really encourage people to be like quite articulate and detailed in their responses, because we expect a lot of people to just kind of click and keep going. So that's helpful. I recognize that it doesn't really capture all of the sort of nuance that's required for something like this. For the people who ask what's the email for those interested in getting involved, it is info@equalityaustralia.org.au. And Ghassan, there is a question, which is, does this go beyond existing conscientious protections for anti-choice health professionals in New South Wales?
I think the short answer is it could. And it's really difficult to say with certainty how the end result of any kind of so maybe if we just step back, we know that in the federal campaign, particularly the very kind of conservative Christian groups were putting forward examples like the GP who doesn't believe in fertility services and doesn't want to provide any information or referral to a patient that comes in asking about fertility services. We don't have a conscientious objection clause in this bill in the same way we did at the federal level, which means you revert back to very standard clauses about you mustn't discriminate against someone in their employment based on their religious beliefs. And there, in that sort of broader general terms, is a concern that a doctor or a pharmacist, for example, could say they're being discriminated against on the basis of their religious belief if they have to provide certain services or information about certain services like fertility services or family planning or contraception, those sorts of services which are contrary to their religious beliefs. So I think it leaves the door open, but it doesn't really kind of answer how those issues will be resolved.
Yeah. The other thing I should mention is that we are, or just in case people are interested, we're already meeting with MPs about this bill. So we are doing a lot of work behind the scenes as well, making sure that we're reaching out to members of the committee, but also other government ministers. So for those people that are parts of organisations that do have relationships with government, I think it's really important that even if it's not the Attorney General, any member of the New South Wales government hears from individuals and organisations about their concern about this development. We can't let the government move forward with this inquiry without hearing a big chorus of concern from as many members of the community as possible.
There's been another question here, which is, will you be sending through case studies? If you have a look on our website, the fact sheets that Ghassan has written have some examples and case studies that are illuminated there. We will likely have more as we sort of start unpacking the bill and stuff on our social media channels, and we'll have more as we do more analysis in different parts of the bill.
Okay. Well, I think that's it, everyone. Thanks again for joining us. It's been an absolute pleasure, and we look forward to being in touch with all of you. And otherwise, please enjoy the rest of your day.